And now I'd like to introduce our speakers. Complete biographies are included with today's PowerPoint. Mark Davis is the Assistant General Counsel for General Dynamics Information Technology Incorporated, responsible for its Health and Civilian Solutions Division, which has more than 20,000 employees and well in excess of $1 billion in annual revenue. He counsels his clients on a diverse set of business and legal issues. Next slide. Michael Elkon is of counsel in the Atlanta office of Fisher & Phillips. He represents management in all areas of employment law in state and federal courts, as well as before state and federal agencies, and specializes in matters concerning employee defection and recruitment. Kevin Mullen of Jenner Block is a litigator who focuses on government contracts and has handled more than 100 bid protest cases. Clients seek his help with agency procurements, subcontracting, and due diligence for mergers and acquisitions, among other matters.
Hello, everybody. This is Kevin Mullen. I'm with the law firm Jenner & Block in Washington, D.C. It's nice to be with you today and to start out our program. As the title suggests, working with contractors, enjoying the upsides, avoiding the downsides of outsourcing work, we intend to focus on the benefits and the risks associated with this strategic approach to business. That is, using employees, personnel outside of your own enterprise, whether it's a commercial business or a government agency, to fulfill your needs. As the first slide suggests, the growth of outsourcing has been quite dramatic in the last 20 years or so. And as this slide says, the U.S. government has been part of that growth. Like commercial companies outsourcing their personnel needs, the U.S. government agencies have been doing very much the same thing. Now let's talk about some of the benefits of this strategic business approach. First of all, outsourcing allows the enterprise, commercial company, or government agency to focus on its core competencies, allow back office activities, other non-core essential business operations to be taken care of by the outsourced partner, typically a company or group of individuals who are very efficient at whatever particular outsourced service is being procured. It allows you, the government agency or the commercial business, to focus on what you do best. Secondly, it allows you a wider range of availability of expertise. You can't be expected to have every possible service expert within your enterprise, and this allows you to go outside and pull in the best people at the best prices. And this trend, especially within government agencies, has been particularly intense for top-tier IT services. If you were to open the Washington Post like I did this morning, there's countless stories about the government's use of the highest and most sophisticated IT services, much like the ones provided by Mark Davis's company, that allow the government to fulfill all the requirements that they need, keep the country safe or whatever else they're responsible for doing. The third benefit that's mentioned on your slide is cost. Because the outsourced partner is more efficient, the cost of procuring their services, even though you are paying them as the commercial enterprise or the government agency, nonetheless allows you to save on what you otherwise would spend having all that expertise in-house under your roof. And you can imagine why that's been an important focus, not only for commercial customers, but especially for government agencies, which, with the way that budgets have been incredibly tight in the last 10 years or so. Even before we got to the foolishness on Capitol Hill with the government shutdown and sequestration and all the others avenues that have been tightening the screws on the budgets. This trend of extreme budget pressure has been on the agencies for some time, and the outsourcing is another potential source of solving that problem for agencies. Next, outsourcing provides an opportunity well, I didn't mean to say next slide. I got to be careful what I say here, apparently. Let me get us back on the correct slide. Growth. If you as an enterprise can focus on your core competencies and grow those, that's where your resource and your intellectual focus is, and you put aside the extraneous, what we'll call extraneous other business activities, and allow those to be outsourced, growth becomes a much more possible result. And finally, outsourcing provides business flexibility and nimbleness. Because you do not have to have all of that expertise, all of that infrastructure under your roof at all times, you cut down on overhead. You avoid volatile hiring and layoffs as demand fluctuates. And you allow yourself to be more quick to react to competitive opportunities. So outsourcing has lots of benefits. Best practices for government agencies. First, I'd like to talk about outsourcing from the perspective of the government agency. Then I'll talk about it from the perspective of the government contractor who would be working as an outsourced contractor for the government. So let's start with the agency perspective. And in particular, let's start with procurement planning. What should the agency be thinking about? What should its program people, its contracts people, its procurement people generally be thinking about as they plan to take advantage of potential outsourcing of its requirements? There are a few things that I've learned over the past 25 years as observing government agencies and working with them on behalf of contractors that I think make good sense as best practices. First, you have to identify the areas of your agency requirements that would fit outsourcing. Certain types of government activities are what's called inherently governmental functions. That's a term of art which by statute prohibits the outsourcing of those particular types of activities. For example, commanding the military, investigating crimes, prosecuting crimes. You get the idea. There are certain things that are inherently, fundamentally, the function of the U.S. government, and they should remain that way, and they shouldn't be outsourced. So that's one consideration. Once as an agency you have identified services that are not inherently governmental, they are candidates for outsourcing. And there are internal processes in the federal agencies for getting approvals for choosing outsourcing candidates. Two other things are important, I think, that are indicated on your slide, procurement planning, and they have to do with doing your market diligence to determine what's available in the marketplace and what you should expect to buy and how much you should expect to pay for those services. So first, conduct market research. It's your typical due diligence of the commercial marketplace. What contractors are out there performing the services you would like to buy, you would like to have outsourced, and determine whether those services that are available are going to fit your needs. And number two, is there adequate competition out there? If there's only one or two companies doing something very specialized that you need, you could be left with very little competition, and that could affect both the availability of the services and the prices you pay. So do your market research, do your homework. Secondly, as part of determining how best to fulfill the government's needs, you should take a look at the job, the project you want performed. What are the requirements you'd like the outsourced entity to perform? How much work? We'll call it a workload analysis. How much work is required? How many people on a full-time basis, FTEs as we like to call them, is this going to take? What would you expect as the agency would be a good mix of skills, and what labor categories are associated with those skills? Do we need, for example, highly skilled technicians, or do we need a lower skill mix because it's very basic work? Those determinations have to be made, compiled, and made ready for a solicitation, which we'll talk about in a minute. Also, as part of that workload analysis and analysis of skill mix and labor categories is the question of labor rates. Typically, outsourced labor is paid for on an hourly basis. Labor categories are specified for different credentialed personnel, and hourly labor rates are associated with those. What, through your market research, can you learn about what you can expect to pay for the types of people you expect to need? Once you've done those things, those very basic things, you're ready not only to develop your procurement budget, because they'll naturally then through arithmetic you'll be able to determine some of the main costs of this contracting activity. You'll have administrative costs, internal costs as well, of course, but you'll be well on your way to determining the agency's budget, and you'll be one step closer to developing the solicitation, which we'll talk about now. With regard to developing the solicitation, that is the published, written, in many instances it's referred to as a request for proposals, but the solicitation setting forth the government's needs and requesting the competitive marketplace to respond with offers. Here are some tips for the government agencies with regard to outsourcing. First of all, take advantage of knowledgeable industry sources. That is, the companies you expect to compete for this work are very good at what they do. That's why they're successful. That's why you want to hire them. Solicit their input. And one way to do that is to issue a draft request for proposals, a draft RFP that you publish and you request industry to provide their input. And it will be valuable input. They will have views with regard to the statement of requirements. How clear is it? Is there an indication that the agency understands what it needs and what it expects to get in terms of skill set, labor categories, and the like? Industry participants will have clear views on that and clear suggestions. Now, of course, many times those suggestions are self-serving, but nonetheless, there's plenty of opportunity here for the agency to learn from the competitors about the most effective form of that solicitation. Secondly, when putting together the RFP, a core part of that is the statement of work, the SOW. That needs to accurately describe the type of work, the scope of the requirements, so that the offerors, as they're called, the bidders, can prepare their proposals in the best way. They can actually respond to your needs directly and effectively. That's a key part of getting the best value for the government. You have to have a clear, fair request for proposals with a clear and accurate statement of work in order to get the best competition. That's how you get the best group of proposals with the most competitive pricing. Next, within that RFP, consider whether contract performance metrics and incentives might apply to this particular project. So, for example, let's say that you're going to outsource a call center where the agency will publish an 800 number, and constituents will call in and ask about whatever the agency provides to the public. And the call center outsourced company will answer those questions. Well, that may be an opportunity to have some metrics about how quickly the phone is answered, how quickly and accurately questions are answered, etc. And associated with those metrics could be, number one, a floor. That is, if you do less than this contractor, it will be unacceptable from a contractual perspective. There might also be incentives. If you exceed certain of these thresholds, perhaps your revenue is increased in some incremental way. So a very, often a very effective way to increase your quality, and although the government pays for it, it is many times well worth that incremental cost. Also, consider using what we call a commercial item type solicitation. Within the government contracts world, there is a label called commercial item contracting, which is what it sounds like. It's a recognition that the government can benefit from the services and products provided by companies that many times are focused on the commercial marketplace and not on the government marketplace. And there's an attempt then to streamline the solicitation requirements, the clauses, all the requirements for compliance that typically apply to traditional government contracts, in recognition that this is a way to increase the sphere of companies that are willing to do business with the government. And because this only applies when the product or service is truly commercial in nature, that is, it is of a type or it is the same type of service or product that's actively provided in the commercial marketplace, the government is assured of that overall commercial pressure on prices. So commercial item type solicitation for an agency actually is a simpler, quicker way to perform a procurement, and you get the benefit of an enlarged competitive pool. So it's a very good idea in terms of outsourcing. In some instances, you just simply can't use a commercial item procurement because the services are too specialized, your needs are too specialized, whatever it might be. But it ought to be considered and considered deliberately as part of your solicitation development. Finally, as part of the solicitation, you have to determine how you're going to evaluate the proposals and what criteria you're going to use to make the contract award. And that is published in the solicitation, of course, so that the offerors can understand what the government is going to use for judging the proposals, and they can tailor their proposals in that way. So, for example, what is the priority of the technical quality versus the price? What are you willing to trade off? How do you describe their priority? Also, what is the priority of the contractor's past performance on similar projects? How is that weighted? Could it be that you choose to use what's called low price technically acceptable, LPTA, approach to the procurement? That is, pass-fail on the technical evaluation, and if you pass and you're the lowest price, you win. Well, you can see that that is fundamentally different than what we call the best value approach, which does some kind of trade-off, some kind of weighing both price and technical, fundamentally different. And certain services are better served with a best value approach. Let's say very high-end technical services. You'd want to have a premium on the technical quality. You might be willing to pay more for it. On the other hand, LPTA might be best sorted for something very basic, let's say very basic IT services of the most routine type. There would be no need to pay a price premium there. You might decide, if we can get an acceptable proposal, there's lots of companies that do this, we'll choose the lowest price. Now, on the other side of that balance is the contractor. So what should the contractor be thinking about as best practices when working with the government on an outsourced basis? So you, the commercial contractor, are going to provide your services to the government. Many times it might be at a government facility. You're sitting next to government employees and performing certain services that are being outsourced. Very typical. Could be that you're doing it at some other location. I think right now one of the most sensitive areas for outsourced work with the government is the recent prevalence of LPTA solicitations, low price technically acceptable solicitations. Within industry, there's a view, and I share it, that the government has trended too far in this direction and in many instances is using LPTA solicitations for inappropriate services. Remember, I mentioned that LPTA, with its pass-fail on the technical side and then low price as the determinant for award, is particularly well suited for low-tech activities, but is probably not so well suited for the high-end services that credentials, everything from PhDs to masters, and extreme experience requirements are called into play. Let's say cybersecurity, which Mark will talk about later, is a good example. In many instances, those kinds of services simply are not, in my opinion, well suited for LPTA, because the government should be focused on the technical quality, and in fact, the government will demand it during contract performance, but many times because we've used LPTA as the solicitation criteria for award, we end up with the low price and not the best quality. So there's a misfit. So with regard to these three bullets on this slide, first of all, I talk about the trend there in the first bullet. It's very real trend. And second is the dilemma that it creates, especially for the incumbent contractor. The incumbent contractor being the contractor who's currently performing those outsourced services for an agency. The contract comes to a natural end. Let's say after 5 years, the government issues a new competitive solicitation to have those services continue. And if the government chooses to use an LPTA type procurement, then the incumbent is in a bad spot from two perspectives. One, the technical advantage that that incumbent has earned after 5 years of experience, knows the agency, knows what they need, has nurtured their staff into a well-oiled machine of experienced folks. All those natural, well-earned advantages are leveled, because now it's just pass-fail. They're not going to be judged and graded in terms of your technical quality, just pass-fail. At the same time, in most instances, the incumbent staff is more experienced by virtue of being five years on the job, and as a result, slightly more expensive. So you've had your technical advantage watered down. You're at a price disadvantage, and in many instances, that incumbent contractor, to continue with the agency, many instances has done an excellent job, but in order to get that follow-on contract, is going to have to cut their costs. And one main way is to have their personnel agree to a pay cut. But that's the dilemma. I think, it's my opinion, that agencies should seriously consider when and where they use LPTA, because I think in many instances you can see through that dynamic that there could be a slow and steady erosion of quality over time for their outsourced services. Next strategic consideration, I think the major topic that you hear talked about in these circles is overseas outsourcing, for obvious reasons. It's yet another way to get cost savings using the dramatically lower pay scale in some countries that can do a lot of this outsourced work very competently. I use the example of the call center. We all know that if we need help with our computer that we've purchased, we pick up the phone, we're likely to talk to someone in India, for example, and they'll help us with it. And the hourly rate of that person you're talking to is obviously much lower than someone who might be across the city from you here in the United States. However, with those added benefits of outsourcing on the cost side, you have to be very careful as a government contractor that you don't violate your compliance obligations. And they come from two main places. When you submit a proposal, you make some disclosures and some representations in your proposal. And some of those have to do with who's doing the work and where is it being done. And if you run afoul of those then, let's say you represent that these folks are going to be working domestically, and then lo and behold, during contract performance, you switch to overseas outsourcing, you could have violated those disclosures and representations upon which the government relied in making the award of the contract to you. So certain of the legal ramifications could be in what's called the Truth in Negotiations Act, TINA. It's a statute that requires that the government have visibility into the same cost-type information you relied upon in reaching your price. Doesn't always apply, but it applies in many procurements. Doesn't apply in a commercial item procurement, for example, but it applies in many other procurements. There also might be representations in your proposal about who will perform the work and where it will be performed, as I mentioned. And one of those statutes that's often incorporated into a request for proposals is the Service Contract Act. Now, the Service Contract Act doesn't prohibit you from using people overseas, but as part of its requirements, you represent where your folks will be working, and you could conceivably run afoul of that representation. Now, one of the questions that I see that we've received here from the audience is, who's responsible for paying the minimum statutory wages to their workers? So an outsourced contractor, in some instances, might have to comply with the Service Contract Act. The minimum wages by region as declared by the Department of Labor, Department of Commerce, Department of Labor. Who's responsible for making sure that those are paid? Well, the prime contractor is responsible for its employees and typically flows down to its subcontracts, the Service Contract Act, which then also applies to the subcontractor. And the subcontractor is responsible for making sure its employees are paid according to the Service Contract Act. So good question. Now, on to the next bullet. The other place where representations and requirements are stated, of course, are in the contract itself. So once you receive the contract, there may be, and as part of reviewing the RFP, you should consider this, there may be restrictions on personnel and subcontractors, where they can be located. So express requirements. There may be that the contracting officer of the agency has to be consulted and provide approval before you subcontract. That's a very common provision. In classified contracts, there's very strict controls over where the work is done. And you can imagine that almost as a blanket statement, overseas work is not allowed. There are some exceptions, but they're not worth mentioning here. And then finally, there are express statutory prohibitions that apply to contracts on doing business in and with certain foreign nations, right? We know about Iran, we know about the Sudan, we know about North Korea, but those are the areas that you have to be concerned about in terms of complying with these requirements. Now, there's a real risk here if you violate the contract or your representations in your proposal. You're at risk of a breach of contract. If you breach the contract, there might be internal contract sanctions, but there's also the threat of termination for default if it's a material breach. There's also the Truth in Negotiations Act, which in essence can trigger fraud liability under the False Claims Act. So basically the theory being, and this is not just a theory, it's been applied and tested in the courts, if you invoice the government for work that does not comply with the contract, in many instances that can be viewed as a false claim, a demand for money from the government that's not based on truth, and you can be liable for both civil and criminal fraud under the False Claims Act. Very intense sanctions for that, and one of them being, as a government contractor, you can be suspended and debarred. You can be ruled ineligible for future contracts by virtue of the fact that you've shown yourself lacking in integrity by virtue of these actions, and you're not considered a responsible contractor. So very important to turn square corners when doing work with the government, and this is no exception. Now with that, I'd like to turn it over to Mark Davis to talk about cybersecurity, and in particular the special risks with outsourcing. So Mark, take it away.
Hey, thanks, Kevin. My name is Mark Davis. I am the Assistant General Counsel for General Dynamics Information Technology, Inc. And as was mentioned, I'm responsible for the health and civilian division within GDIT. I appreciate having the opportunity to speak with you today. And, prior to discussing cybersecurity, I just thought I'd add a few comments from my perspective as in-house counsel on what Kevin was talking about with respect to outsourcing. First, and this comes from my experience with the UK in particular, I think it would be wise for the government procurement planners to consider borrowing some of the fundamentals of the competitive dialogue in the UK, where for particularly complex procurements, the government engages with individual potential competitors, even possibly during the procurement phase, for information and insight into the available solutions. Now, I know there'll be some challenges under the FAR with discussions, but I found that to be very useful, and it really improves the quality of the procurement and responses received. Next, I'd like to mention that there are reasonable service level agreements that I think can benefit the government and contractors by controlling costs and risks, and I would encourage the government to consider inserting those in the appropriate contracts, cost plus, T&M, and so forth. As an observation, low price technically acceptable, in my experience, seems to be much more prevalent in DOD right now than it is in any of the civilian procurements. Perhaps it has something to do with the more basic procurements that DOD may be undertaking, but it is interesting. And with regard to outsourcing overseas, Kevin did a good job discussing that. As in-house counsel, the primary risks that I see are really two. One are disparate and unfamiliar labor laws and tax implications, for example, the value-added tax, in countries where the work is to be outsourced. And as Kevin mentioned, the Foreign Corrupt Practices Act and the considerations involved there. Now to move on to my slide and my presentation here, I will be addressing cybersecurity as it affects corporate governance and risk assessment. I note that cybersecurity has become more and more important for federal government contractors. Although a fruitful area for detailed legal discussion, which we really don't have time to get into right now, I will focus my attention on cybersecurity as it relates to proper corporate governance and risk assessment. First, from my perspective, corporate leaders really play an integral role in cybersecurity vigilance, and companies need to be aware of the February 12, 2014 NIST framework for improving critical infrastructure cybersecurity, version 1, which promises a concise way for senior executives of all federal government contractors to distill the fundamental concepts of cybersecurity risk, to assess an organization's management of these risks, and to become aware of how their organization stacks up at a high level against existing cybersecurity standards, guidelines, and practices. Now, I caution that involvement of corporate boards and senior executives is critical to the strength and efficacy of any cybersecurity program. Practically speaking, government contractors should avoid relegating cybersecurity compliance to their IT departments. That's something that's very easy to do. It's probably inherent in the nature of the business. It's been done for over the years, but cybersecurity has come to the forefront, and I would seriously advise against that at this time. For example, company needs to be aware that both common law negligence and shareholder derivative suits are becoming more prevalent with the introduction of more cybersecurity risks and particularly published standards of measurement for adequate cybersecurity controls. Moreover, it's incumbent upon corporate counsel to include as an essential element of a proper and thorough risk analysis in most business reviews or financial management reviews, a thorough cybersecurity review and analysis. As part of this review, we as corporate counsel need to be cognizant of potential sweeping government indemnification and liquidated damages clauses and how they relate to cybersecurity. Now, what are the impacts of cybersecurity inadequacies on government contractors? I won't belabor the point. As Kevin mentioned, though, you can have something as benign as a simple non-compliance of the contract. You could have a show cause or cure notice, which could result from something as simple as an inadvertent release of personally identifiable information, It violates contractual information distribution limitations. You could have a government termination for default. Of course, you'd have reprocurement costs and other penalties, and this could affect the contractor's responsibility determination based on the government's assessment of that contractor's ability, that contractor's capabilities and systems, and of course their resources to perform, and whether they're adequate to perform a solicited opportunity. In that vein, you can have past performance evaluations, which can be seriously impacted. For example, a denial of services attack may cause contractors not to meet their SLAs, which in turn may adversely impact the contractor's past performance ratings or lower its award fee scores. Nothing that we like to see in our business. Now, serious cybersecurity violations may even impact the contractor's ability to compete. For example, under the Consolidated Appropriations Act of 2014, a contractor can be excluded from a competition after being designated a supply chain risk. Kevin mentioned as well, suspension and debarment is a possibility with willful noncompliance and resulting non-responsibility. And you also have the False Claims Act. And we have the omnipresent FCA implied certification theory, which may be asserted when a contractor fails to implement appropriate and contractually required cybersecurity safeguards. As Kevin mentioned, the act of invoicing itself implies compliance with governing federal rules that are a precondition to payment, and thus contract cybersecurity noncompliance, even unrelated to a claim for payment, may give rise to a potential FCA violation, where you have civil and criminal fraud allegations and treble damages. Also, you have state law implications. All states have their own reporting requirements, for example, with respect to personally identifiable information or personal health information. And the cybersecurity requirements can really impact that. We've implemented a very strong program at GDIT to protect that type of data, and it really flows into our cybersecurity program. And as you know, there are penalties under state law, not to mention the third-party liability with the individuals potentially bringing suits and class actions against contractors for unauthorized release of their data. And in that vein, you have third-party liability where a prime contractor experiences a cyber intrusion of its network, and a business partner of the contractor incurs a loss of its own intellectual property or has its own network intrusion. The prime contractor has potential exposure from both a contractual and a common law breach basis, and the contractors face a potential tort exposure and the accompanying potential liability for direct, consequential, and punitive damages. I'd also like to mention the audit considerations exist with respect to cybersecurity protections. Contractors face many new laws, regulations, and standards that allow the government to audit and monitor contractor compliance with federal cybersecurity requirements. For example, GSA and OMB demand broad audit rights with regard to contractor IT systems to ensure adequate cybersecurity measures. Also, DHS has a program to oversee compliance with FISMA, OMB guidance, and applicable NIST guidelines for contractors and vendors that provide services to or manage systems on behalf of the Department of Homeland Security. Now, cybersecurity costs, of course, need to be considered in the budgets of the contractors. These costs may be significant, and I would advise a balance between robust protections and the potential non-recoverability of these costs. It's always a cost trade-off. But those costs, for example, they have to be recovered on an indirect basis. First of all, cybersecurity costs are recoverable only on an indirect basis. And secondly, those costs can be quite significant, especially after a breach or under a fixed price contract. Now, insurance may also be available for cyber risk. Okay, it's potentially available in existing insurance policies. You have business interruption, employee dishonesty, commercial general liability, professional and EEO insurance, and cybersecurity coverage is frequently unclear and fraught with exclusions under these policies. There does seem to be an emerging insurance market that would benefit contractors as well as the government in attempting to fill the gaps in those policies. The real challenge is that there's no standard cybersecurity insurance policy, and it makes it difficult to compare coverages and exclusions. Some of the names might be network liability, electronic media liability, technology errors and omissions, data network and restoration losses, or forensic and investigation expenses. Now, I do note that Congress has considered providing broad cybersecurity indemnification to contractors. In December 2013, a bill was introduced into the House of Representatives to expand the coverage of the Safety Act, which was implemented to indemnify contractors for terrorist acts. And the bill proposed that the coverage be extended to cyber attacks. Now, this hasn't really gotten any traction to date, but I know it's been under consideration. Other traditional government contractor defenses and theories of immunity for cybersecurity liability exist. Okay, you have a handful of traditional defenses and immunities that